I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That's another very risky argument which Mr. Sibal made. That why did the government openly stated that dead bodies would come, and I would earnestly urge not to condone this. This is a threat in public.
It's a law and order situation.
I leave it. No, it's a threat to death. I would, my lord, earnestly request your lordships, my lord, that it cannot be taken serious, my lord, lightly by the constitutional.
But that
I
would
leave
be
it
a ground for unseating a.
In a situation where the House has been summoned following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. When the government calls for the session being called, in exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures that authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent the ordinary legislative process of no confidence motion from running its due course. Lord 74. In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. Sir, I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That is itself an enough ground in my respectful submission. Lord, kindly, my lord, thereafter see, your lordships were pleased to, my lord, para 77 at page 1386. Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordships directed that immediate floor test, and the only purpose was, I'm sorry, my lords are typing. I'm sorry,
Yes.
The object of my lord was, no, your lordships may complete. I'm sorry, no, that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships, my lord, sat at night in case of Karnataka. There are several such instances. And therefore, I am not reading, my lord, but there are large number of cases, my lord, which your lordships were pleased to reproduce of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In circumstances as they have emerged in this case, the exercise of authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine that the trust vote was not the appropriate course of action on 16th March. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. Well, that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin to which governor should not be a party. Kindly last, para 50. Para is necessary to ascertain whether the Council of Ministers headed by the Chief Minister has the confidence of the House. The continuous existence of that confidence is crucial to the legitimacy and hence survival of the government. I could never have put it, like this. Continuous existence of that trust gives you the legitimacy in democracy. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have the faith of the legislative body as a collective entity, particularly where the members resigned in an expression of lack of faith in the existing government. The convening of a floor test is the surest method of assessing the impact of resignations on the collective will of the House. The consequence of the acceptance of a resignation is to reduce the numerical strength of the House. Until the resignations are accepted, members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 193(3)(b). Whether in a situation such as the present, an elected government is entitled to continue despite resignations of 22 of its members has a significant bearing on the issue of confidence. But if this is right, then the governor is right that if 47 people want to withdraw support, it is the most relevant fact to be considered while deciding the floor test. Nothing beyond that. Governor does nothing beyond that. Neither the governor nor, for that matter, the court can entrench upon the power of speaker, but the pendency of proceedings before the speaker cannot be a valid basis not to have the confidence of the House in the government determined by convening of a floor test. Added to it is a factual circumstance in the present case that the speaker accept. No, that's on the facts of the case. Kindly allow me last para 81. We have highlighted above factual scenario only to emphasize that convening of a trust vote is of crucial importance to affirm fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. Now this is 11 is important. The argument was that floor test could not have been ordered because this side and other independents, etc., who withdrew support from the government, they should have gone for no confidence motion. And this is a new point, my lord, which I would be urging for your lordship's consideration, not argued, my lord, so far. First of all, my lord, whether it is a floor test, which is a motion of confidence, or a no confidence motion, my lord, which is negatively worded, the result is the same. And therefore, there can never be a ground to invoke your lordship's equity jurisdiction in a 226. Floor test also, the numbers will be counted and people would decide whether I have the majority. In no confidence, numbers will be counted and members would decide whether I have the majority. But there is something more than that. Lord, please come to PDF page 40 of Convenience Compilation 3C. Lord, the provision in the Maharashtra Legislative Assembly rules regarding no confidence motion. Lord, your lordships are confronted with a situation where the governor is receiving representations that we have withdrawn support, we want to withdraw support, etc., etc. I'm not repeating. There is a threat of violence. There is, in fact, violence. Attacks are taking place at the houses. And now, my lord, the submission is that you should have allowed the no confidence route rather than directing a floor test. Please see, my lord, now page 40 of my lord's Convenience Compilation 3.
3C.
CC3, my lord, Convenience Compilation 3. My lord, that is part of rules of Maharashtra Legislative Assembly rules. Your lordships have said, my lord, please bear in mind that such floor test cannot brook any delay. And why is this reliance on no confidence motion? Maybe they wanted more time, which the governor prevented them from doing. para 90, rule 95. Your lordships have that rule 95.
Yes.
Two things I'll say at the outset, and I'll read this.
3C.
First,
3C, okay.
3C.
First, any member can move a no confidence motion only when House is in session, not otherwise. House was not in session. Number two, it depends upon the discretion of the speaker whether to allow the motion to be placed or tabled or not. It's not a right. So again, I'll be dependent upon the discretion to be used by the speaker if I'm the elected representative. This is what, my lord, therefore, governor says that no, you hold a session. Kindly see, my lord, rule 95. So next session may be after 15 days, after 1 month, after 5 months. We do not know. Your lordships are deciding this constitutional principle that whether the governor was right in directing summoning of the House for floor test, and they are saying that no confidence motion was the route, meaning thereby this threat, allurement, violence, etc., continues, and the governor's satisfaction that prima facie the government has lost confidence would continue without any legitimacy. My lord, borrowing your lordship's very, my lord, pertinent expression. After the member has asked for leave of the assembly to make the motion, the speaker shall read the motion to the assembly and request those members who are in favor. That's the procedure, my lord, how the motion would be passed or failed. So, my lord, this is no remedy in fact situation like this. Because the taste, my lord, right from the state of Rajasthan till Shivraj Singh Chauhan is, it cannot brook any delay. Last 3 points. Another option was 356, which is frowned upon, and nobody, that has to be the last resort. And how, that happened, please come to, as a last submission, written, the documents which I have placed. The governor received 2 letters that now Eknath Shinde has the majority. And, another very risky argument which Mr. Sibal made, that why did the governor call Eknath Shinde to form the governor? And why not the president of the party was consulted? My lord, the governor knows only the elected leader of the house. He is not concerned with political parties. There are political parties where leader of the house is in fact the leader and president is not controlling him from somewhere else. Governor has to contact the elected leader of the legislative party. When he is shown, my lord, I'll show, my lord, those documents. There are 2 letters, my lord, I'll show that document. Because, my lord, every party has a different structure. Kindly see, my lord, the mischief in this argument. I'm saying argument, not mischief in making of the submission. My lord, mischief. I'm sorry, my lord. I thought, my lord,
They're relieved with your clarification.
No. It was not correctly worded, my lord. The potential mischief if this argument is, my lord, accepted. That's what I wanted to convey. My lord, every party has a different party infrastructure. For example, in some parties, the highest authority is the general secretary. There is a Politburo in Communist Party. General secretary is the highest authority. In some, my lord, there is a body, 5 people, my lord, committee or something. In some, there is a president. There may be a dispute who is the president. Governor would not enter into that. Governor would say that who is the leader of the legislative party. Governor would deal with only leader of the legislative party, and Mr. Uddhav Thackeray, who did not face the confidence and therefore he resigned, is not even a member of the Legislative Assembly. My lord, kindly see page 47, PDF 47 of the governor's compilation. Well, has openly stated that dead bodies would come, and I would, my lord, earnestly urge, my lord, not to condone this. My lord, this is a threat in public platform. My lord, let us not, my lord, lessen the gravity of it. It's a very serious thing. I leave it at that.
Law and order situation.
I leave it. No, my lord. It can be law and order situation also, but if that law and order situation is being created to bring pressure on the legislative process, then it's not just a law and order situation. It is one of the major consideration for the governor that yes, he seems to have lost majority and now open threats are being administered that you come in our fold or you will be sent to post-mortem. It's a threat to death. I would, my lord, honestly request your lordships, my lord, that it cannot be taken serious, my lord, lightly by the constitutional.
But that
I leave
would
it
be a
at that.
ground for unseating a government. I mean, ultimately, that somebody who makes
I'm
that
sorry.
threat is subject to section 156(3), is subject
I'm
to
sorry.
an FIR. You can do what you want about that
Kindly allow me
threat
to,
which is given.
my lord, put it differently. My lord, that's where the perception differs. If I say that because somebody is threatening, you face the floor test, then your lordships are right. But when I have the letters that we want to withdraw support and we are being threatened, then it's not that reason. That's a ground, not the reason.
We'll hear what Mr. Sibyl and they have to say in rejoined, I think.
Yes. My lord, one clarification, not on the merits of the case. I checked up the couplet, my lord, which I started with.
This was not Barilvi.
Wasim, it's by Dr. Bashir Badra. They are contemporaries.
Oh.
Their style of writing is very similar. It's likely to mislead, my lord, every reader. It's by Dr. Bashir Badra. He is no longer there, my lord. Wasim Barelvi Sahib is.
You're giving credit where it is due.
Yes, my lord. When especially when he's not. Dr. Wasim Barelvi is also, my lord, he is alive. Dr. Badra, my lord, passed away recently. But contemporaries, same age group.
Thank you, Mr.
Obliged to